Hi, it's Doug Isenberg, and I'm excited for what I know will be an important and interesting discussion with two of the most important people responsible for overseeing domain name disputes worldwide, including under the Uniform Domain Name Dispute Resolution Policy, or UDRP. I am joined today by two leaders at WIPO, the World Intellectual Property Organization in Geneva. WIPO is an agency of the United Nations, and through its Arbitration and Mediation Center, is the leading provider of domain name dispute services. So with me today from Geneva are two men I have known personally for many years, so I will go ahead and introduce them right now. First, Erik Wilbers is director of WIPO's Arbitration and Mediation Center. Erik has been with WIPO since 1996, which I should note is just about the time that cybersquatting and domain name disputes started to arise, so almost no one knows more about the UDRP than Erik. Also joining us is Brian Beckham, head of WIPO's Internet Dispute Resolution section, where he is responsible for day-to-day management and oversight of all WIPO domain name operations. Erik and Brian, I would normally be seeing you in Geneva about this time of the year for the annual meeting of WIPO domain name panelists, and I know WIPO also usually holds a domain name workshop at this time as well, but sadly, of course, those meetings, like so much else, have been canceled because of the coronavirus pandemic. But at least it's great to see you here online, and it's great that you are taking the time to share your insights about domain name disputes with everyone watching this video. It's certainly been an interesting year in just about every way imaginable, and that applies to domain name disputes too. And we're talking at a very peculiar and interesting time near the end of November 2020. I understand that you actually have a bit of breaking news, as they share in the cable TV business, to share with us today, because a milestone has just occurred at WIPO with the filing of the 50,000th domain name case. Erik, since you've been with WIPO since before the first UDRP case was even decided almost 21 years ago, I wonder if we could start by having you provide a little bit of historical perspective about the growth in domain name disputes generally. And then Brian, maybe you can tell us a bit about this milestone case that was just filed and how WIPO is handling its tremendous caseload these days. So Erik?
Well, thank you, Doug. It's a great pleasure for me to be on here together with my colleague Brian. Your generous introduction was nice to hear, but this is of course very much a team effort on the part of WIPO, the Arbitration Mediation Center. Yes, when the first case under the UDRP came in, this was in December 1999, seems ages ago. And it was very hard, of course, at the time to have expected the system to have taken such a flight to the point where now, 20 years later, we are looking at case number 50,000, and it's running on and running on. And Brian will explain that a bit more. The roots, as you noted, of the UDRP system are indeed at WIPO. After a big international process, our then Director General, Francis Gurry, proposed this system, which was adopted by ICANN, and we, as they say, never looked back, and the system evolved under our kind of custodianship, and certainly to include the likes of you and others as panelists who have helped this along. I'm very pleased that we are renewing our contact on this fine occasion, and as we have had the occasion to see so many times with us in Geneva.
Great, thanks, Erik. So Brian, 50,000 cases is a lot, and especially considering that the UDRP is, as I said, only a little more than 20 years old. What is going on? I know there's a surge in cases, but what can you tell us about this milestone case that has just been filed?
Yeah, thanks, Doug. Thanks for the opportunity to join you here. I first want to just mention, to kind of dovetail on what Erik just said, it's really a team effort here. We have about 30 people on the team, and of course colleagues that have come and gone over the years. working these days quite literally around the clock. You mentioned 50,000 cases, which is a big milestone. We happen to know that this case involves Discover, the financial services company over in the United States. And it happens to be what they call a typo or typo squatting variation of a brand, which is a very common type of case that's filed before us. Basically, it's designed to trick users. And especially nowadays, in the early days back in the late 90s when the commercial internet was still getting off the ground, a lot of brand owners weren't really too sure whether they should buy up domain names corresponding to their brands. And so basically speculators beat them to the punch and said, well, we'll turn this over to you for some money. So there was a kind of a feeling there was some extortion going on. And that still happens to some extent nowadays, but as is, of course, we can't talk about this case in any detail except to say that it's been filed and the identity of the domain name. But we do know that, and it's interesting to see that this case happens to be in the financial services sector, and it's a typo, which, as I say, is designed to trick consumers, because nowadays, unfortunately, a pretty steady ratio of our cases have to do with fraud that's meant to trick consumers. We see, fake invoices going out. We see phishing campaigns. We see obviously fake goods being sold on websites. So, with the world, especially nowadays, working online, shopping online, a lot of people are really living out of their homes and working off of devices and computers. It unfortunately means that the bad guys are hard at work as well. And we've actually seen that in spades over here in Geneva. We've had not only we're hitting a lot of milestones this year. 2020 it's known for a lot of things. 50,000 cases filed with WIPO. And in fact, 5 of the 6 busiest months of those 20 years that we've been doing these cases have come in this calendar year. So as I say, unfortunately, the bad guys are hard at work, and it's keeping brand owners on their toes. But the good news, if I can put it that way, is that the UDRP, when it was designed 20 years ago, it was done in a way that it's been able to adapt with the different types of behaviors that we're seeing online, so that it's still very relevant today.
And it's interesting that this milestone case, as you said, has been filed by Discover, which is in the banking and financial service industry, as you noted, which is, because I know WIPO tracks a lot of data about the domain name dispute filings, and over all the years, companies in the banking and financial services industry have been the most popular, I believe, filers of domain name disputes. I think more than 10% of all cases have been filed by companies in that industry, filed, I think, by those in the retail industry, and then, interestingly, of course, in 2020, by those in the biotech and pharmaceutical industry, which is also interesting, because I know that you've seen an uptick in filings related to the times that we're living in, that is sort of coronavirus specific domain names, or domain names being used in connection with activities related to the pandemic. What can you tell us about that?
Yeah, Doc, that's right. We are continuing our operations, of course, in these difficult times for many. And we were already online ourselves, so that operation is continuing pretty seamlessly ourselves. But in terms of the domain name case filing, we have been seeing now an increasing number of cases in the pharma biotech area, and that includes over 100 cases by now, where some corona-related term, COVID corona-related term, is actually included in the domain name in some fashion, or where the domain name itself is clearly related to the pandemic. So this could be either the name of a, by now, rather famous pharmaceutical company or product, or it could actually be a connection, quite simply, between the corona or COVID name and any famous brand, in order to, of course, attract hits to that site. So we've been seeing a fair number of those, predictably, just like every time that there's something of a big alarming magnitude happening in the world, it seems to connect pretty quickly into cybersquatting.
Right. I've been doing this work for close to 25 years now myself, and as I tell my clients all the time, nothing surprises me. And as both of you know, the cyber squatters, in many ways are a bit ahead of the curve. And so the issues, Brian, that you mentioned that we sort of saw in the early days, some of them are still around, but there are a lot of new issues that are arising, which I assume is what is contributing to an ongoing increase in the total number of filings. So not only has WIPO reached this milestone with the 50,000th domain name dispute filing in general, but it's my understanding, at least as I have looked at the data, and I like to track these things pretty regularly, that the number of domain name dispute filings this year in 2020 will soon reach a record year. 2019, I think, was already a record year, and any day now, if not today, it looks like the number of filings will surpass what we saw in all of 2019 and be on track for a 10 or 11 or 12% increase. So how is WIPO managing? Erik, as you said, I think the answer succinctly is quite well, because the UDRP was designed to be handled online. So despite the times that we're living in, WIPO seems to be handling everything very well. But what can you tell us generally as to why we are seeing a record year in the number of filings?
I think we can speculate a bit about that, of course. I would say at least a couple of reasons. And one of them is probably a negative one, which is that at a time when increasing numbers of people and companies are now using the internet to communicate, shop, do our business online, I suppose that the target has just become more obvious and more ubiquitous. There are more people that are now susceptible of, being cyber squatted. So that's probably one side of things. On the positive side, we also are assuming from the numbers that trademark owners themselves are becoming more alert at this time to the need to maximize and optimize their online presence themselves, which leads them, of course, to try to recuperate those names which they believe are good for their online commerce at these times.
I was just going to add, I think there's maybe a couple of other things that for the past few years we've kind of identified that feed into these upward trends. Of course, a lot of people will know about new gTLDs. They've been with us for 5 or 6 years now, and those have been a steady percentage of cases. And we also continue to add. So the UDRP, as we mentioned, it was designed back in 1999, and already back then, and even still today, it's not only been adopted by the generic top-level domains, so the .coms, the .orgs, .nets, that sort of thing, but increasingly, even still today, by country code or ccTLD registry. So that's, for example, some recent additions that have, signed up for the WIPO services, UA for the Ukraine, CN for China, IO. So these factors in combination with the world, the ubiquity of the internet and online commerce, new gTLDs, ccTLDs, these all contribute to the steady caseload that we see.
And let me ask you about another question, which seems like it might be adding to the increase in the number of cases, and that's the difficulty these days in ascertaining who the registrant of any particular domain name is, given both the sort of increased use of privacy and proxy services, as well as the GDPR, the European Union's General Data Protection Regulation, and other tricks, if you will, that cyber squatters employ, makes it, I think, I've seen in my practice, a little more challenging to identify the larger cyber squatters. As you may know, I filed the largest UDRP complaint ever a number of years ago that included 1,500 domain names in one complaint. We don't see anything like that anymore, and I think that's because we're living in different times, which creates new challenges for trademark owners, perhaps leading them to file more complaints that include sometimes fewer domain names than in the past. Is that accurate?
Yeah, no, it's a good point, and this is a bit more difficult to track with precision. But of course, since the GDPR has come into force, and of course there are other privacy regulations out there, but this is really one that's impacting the internet in a big way. As you say, it makes it a lot more difficult for brand owners to ascertain the identity of a registrant. So we know that, normally speaking, the UDRP is sort of the end of the enforcement road. The UDRP or court would be the end of the road. Normally, brand owners would reach out informally to a registrant and ask if they wanted to sell the domain name or assert their rights. But that's becoming more and more difficult because a lot of domain names nowadays are effectively behind a permanent privacy curtain. And so brand owners have to reach out. In the past, you could go online in a matter of seconds, find the registrant's information. Of course, typically a lot of that was fake information. But in any event, you could at least get an email address, whereas nowadays you're sort of at the mercy of one of a couple of thousand registrars who are the businesses that sell domain names to the end users. There are processes where brand owners can fill out forms and ask for the information, and we hear different reports about how effective that type of outreach is. So, and again, this is a very rough statistics. It's hard to put a real precise number on this, but what we've seen basically since 2007, 2018, 2019 is kind of each year about a 4% increase in the cases involving a privacy or proxy service. So that's a good point. That probably also adds to the increase in case numbers, the fact that it's more difficult for brand owners to solve their problems more informally before getting to the UDRP phase of enforcement.
Doug, maybe just briefly adding to Brian on this one. We're talking here, of course, about some of the adverse consequences for rights owners, for trademark holders, of this restriction in access to who is data. So that impacts on domain name dispute resolution, but of course it also impacts importantly on rights holders' possibilities to get behind infringements of trademark rights or copyright in the domain name system on the internet, where the domain name itself that's being used might itself not be infringing. So we're looking, from an enforcement perspective, we're looking really at the problem that is impacting domain name dispute resolution, but also the enforcement of trademark and copyright through content where the domain name itself might not be the problem.
Right. And Brian, I think you had mentioned earlier sort of this increase in phishing or employment scams. I've seen a lot of clients encounter this issue where a cyber squatter will register a domain name and then create a web page that appears to be one for accepting job applications. Is this a common tactic that you're seeing today? Obviously, they can only be addressed through the UDRP to the extent that the domain names might be identical or confusingly similar to the complainant's trademarks. Getting Erik to your point that that there are issues outside of domain name disputes that are still very important to brand owners. But these types of employment scams and other phishing activities, how prevalent are they? And I'll ask either or both of you, what sort of other trends are you seeing these days in domain name dispute filings?
I think in terms of the employment scams, those don't seem to come across our radar as often as the phishing. That seems to be pretty prevalent nowadays. We've seen, unfortunately, a number of cases involving fake invoices, which sometimes only come to light once it could be a law firm or an accounting firm chases up a client for payment on a bill, and they say, well, we've already paid you. And then, of course, when the puzzle pieces start to come together, they realize that this was done through an email address which looked awfully similar but was different. So those tend to be, I would say, more frequently the types of fraudulent behavior that we're seeing nowadays.
Maybe I don't have much specific to add on that, other than to say that with a little bit of distance, and I think you know this, Doug, as being a frequently appointed panelist for us yourself, I feel that there's a certain maturing of the cases, both on the filing side and on the deciding side, in terms of jurisprudence. The system has taken many years to evolve with online behavior, with the expansion of the domain name system in all of its forms. But I think that substantively speaking, legally speaking, we are at a period where we are benefiting from our panelists having really thought through many of the core legal issues that allow them to take reasonable decisions in these cases. So a certain maturing, perhaps jurisprudentially speaking. I'm not sure if Brian would share that position.
Absolutely, I think the maturing of the jurisprudence, it's really borne out in what we call the WIPO Jurisprudential Overview. We're on our third edition currently, and this is basically a look back in the rearview mirror at these tens of thousands of cases, boiling down what are the core consensus positions of panelists on certain topics. So this can be what's the test for identity or confusing similarity. One of the ones that's particularly relevant, you mentioned earlier, the GDPR and privacy and consolidation, the 1,500 domain names case. Those are obviously less frequent nowadays, but we do have a section in the overview where we've basically looked back across hundreds of cases and identified, well, what are panelists looking at to help answer that question of, are these nominally different parties actually associated somehow, acting in concert? So looking at things like IP addresses, web hosts, identity of registrars, dates of registrations. There's a list of about a dozen or 15 items that are captured there. And I just wanted to go back to the question you asked earlier about the kind of the broader trends. And of course, one thing to look at is the trends within the cases. But of course, one of the things that I think is emerging a bit nowadays is there's a lot of discussions around what in the policy circles they call DNS abuse, and sort of a recognition that this has always really been the case, but I think there's a growing recognition that the UDRP it's great at doing its job and it does what it does very well, but it's not a panacea. It's one piece of an enforcement puzzle, and so nowadays brand owners are looking, I think, a lot more at web hosts directly contacting the registrar, sometimes even the registry, especially in the case of a national registry. They're looking to, can the UDRP model be applied to platforms? So we hear from brand owners that whether it has to do with content or goods passing back and forth on different platforms, that those processes, although there's a lot behind them, they tend to feel like a bit of a black box still for brand owners, whereas the UDRP, the criteria are published, they're known, and you should be able to look at the three legal criteria and ascertain with reasonable certainty which side of the line your case is going to fall on. And so we do hear questions from brand owners, well, can we take that more kind of open, transparent model with a publicly rendered decision by an expert and apply that outside of the UDRP to other spaces on the internet?
One thing that also I just wanted to loop back to that you said earlier, or just a moment ago, about the WIPO overview. I have to give a compliment because WIPO is not the only UDRP service provider, but WIPO is sort of the caretaker of the UDRP, the leading, the most popular, the most active provider of UDRP services. And you see the overview, Brian, that you mentioned, the consensus overview of WIPO cases, of UDRP cases that WIPO has created, cited frequently, not only in decisions at WIPO, but also at the other providers. So it's really a great service that WIPO has provided through the overview and also through a lot of the other documents and resources that are on the WIPO website itself, including a model complaint, a model response. And I'd like to think that, over the past 21 years, there's been a bit of a maturing of the UDRP and domain name dispute process, and that both trademark owners as complainants and domain name registrants as respondents have a much better familiarity with what the domain name dispute process is. And hopefully, I'd like to think we're seeing better quality filings as well these days. Any thoughts about that or other resources that WIPO offers that are important for parties to be aware of?
First I want to pick up, thanks for that compliment, of course, to the team here, but I want to pick up, Doug, on this, on the whole meaning, the larger function of having this jurisprudential overview before we get to, what does this do for the actual consistency of filing, as you already mentioned, and what other tools do we have? What I find really quite fascinating is the whole question: how do you, in such a global system, build and then hold together and more or less consistently apply jurisprudence across, in our case, 50,000 cases with, thousands and thousands of different parties and 400 to 500 WIPO panelists and all these different circumstances over time with an evolving domain name system in the background. This system only works, of course, as a global system. That's what it's intended for, and that really means that you can't get into too many jurisdictional exceptions or panelists splitting up on half of the issues. It would defeat this universal purpose. And so I find this quite fascinating. It's almost on the level of an experiment in how do you keep these things together. The collaboration between the panelists and WIPO has been very important through the panelist meetings which you mentioned, through the workshops that we give. But this jurisprudential overview is, I think, where it all comes together, where we kind of synthesize your collective opinions, and it has held together as it got built on. Maybe Brian can say a few more things about one or two other tools that are helpful in the same regard.
Yeah, thanks. I as you mentioned, Doug, I think we had kind of roughly identified about 3/4 or even more of not only pleadings but decisions nowadays cite to the overview. So that's really helped establish a lot of predictability around these cases, and that's useful for everyone in the ecosystem. For the registrants, there's a very rich aftermarket in buying and selling domain names. For brand owners, so wherever you fit in this equation, for the registration interests themselves, the registries and the registrars to know when they can point people to the UDRP. So for everyone in this ecosystem, the WIPO overview has really brought I think a very welcome degree of predictability and stability. Of course, that's not to say, as with any system of law, there may be an outlier case here or there that someone would disagree with. That's the nature of the law. But overall, I think it's been very well received in helping to bring predictability. And I think it's exactly as you say. You mentioned the term caretaker. I think that's a label that we very much share. I can say across the team at all levels, we take what we consider a responsibility of running the UDRP very seriously. So it's very heartwarming, encouraging. I must say, to hear that term used by someone else, because we feel it every day. We take the responsibility very seriously. To see that picked up on outside means a lot, I know, for the team. One other thing to point to, two other things actually, that in terms of resources, of course, as you mentioned, there's lots of resources. Model pleadings, Erik mentioned, we do the panelist meeting and our our UDRP workshop. Normally that's every fall. Of course, that's not possible this year. We very much hope to do that again soon. This is 2 days of training. I can't think of any better legal training for anyone interested in this area. So hopefully we get to do that and invite people back to Geneva one of these days soon. Just to mention 2 other pretty useful resources. One is we've put together an FAQ on what are the questions around privacy and domain name disputes. So an FAQ around GDPR privacy related issues, if you will. So not only the practical nuts and bolts of how do you find information, how do you file a case, but what does it mean for the procedure of a case, consolidation questions, what does it mean for the substance of a case? For example, how do you show a pattern of bad faith if you don't know the identity of the registrant? So we tried to walk through some of the more frequently encountered questions around that topic. And then I mentioned earlier that ccTLDs are a pretty stable percentage of our cases, not only over the years, but especially in recent years, and especially as we continue to add important ccTLDs to our roster. We've actually recently gone through and we completely revamped all of our web pages. For each ccTLD, we have a web page where we basically walk you through. A lot of times those ccTLDs would just adopt the UDRP, in which case we have the existing UDRP resources that people can turn to. But in about half of the ccTLDs that we work with, they've actually made small variations to the UDRP for their own national systems. So that can be anything from the language they use to the rights that can be invoked. So under the UDRP, that's based on trademarks. For some national systems, they've looked to other identifiers that can be personal names, business names, geographical identifiers. So we really walk people through what are the material differences between the UDRP and each of those individual ccTLDs. So that's a resource that I really commend if people have disputes in ccTLDs.
Yeah, and as far as ccTLDs are concerned, of course, as you mentioned, a number of them actually use the UDRP, have adopted the UDRP itself. I think .co, the ccTLD for Colombia, probably remains the most frequently disputed ccTLD in the cases that the WIPO handles. I will also say, at the risk of a bit of self-promotion, so please forgive me, but I've been publishing a number of videos lately on my GigaLaw website as part of a Masterclass. There's a series of 14 videos on domain name disputes and on the UDRP. But obviously, I'm spending literally every day of my practice on the WIPO website, consulting either the overview or the ccTLD database or other information. So you've got a tremendous amount on your plate. I know WIPO issued a press release early in the pandemic that you had seen this surge in filings, and obviously, as you pointed out, nothing has slowed down. So thank you for what you're doing. For making this important operation, run as smoothly as it does. So unless either one of you has any other comments, and I'll pause there for a minute if you do. Erik, did you have anything else to add?
Thank you. Yeah, Doc, I could only interrupt you by for the reason of complimenting you on everything that you do to spread the message about this available tool, and in the way that you do that, which is often very creative and with great quality. So thank you very much for that. On our side, it remains a shared effort and shared very much with our panelists, including yourself. So it's a wonderful experiment that continues on to the next 20 years.
Great. Thank you both very much for being here today. Thank you.
Thank you.
Pleasure.